Hello, everybody. Happy to see y'all here. Welcome to AP Gov and Politics Cram. Tonight, we're going to be talking about Unit 3, Civil Liberties and Civil Rights. If you can hear me, feel free to say hi in the chat. All right, let's wait, give it a few minutes, let people connect, things like that, and then we'll get going. All right. Oh, hello. We have one person. Hooray. Oh, a couple. Here we go. Fantastic. All right. While we're waiting for people to sign on, let's do a quick poll. What is your favorite part of AP Government and Politics? So, is it the SCOTUS cases? Do you love talking about the Supreme Court? Is it the required docs? Do you like the history of the required documents? Is it just the general class contents? Or is it political debates in your classroom? All right, let's see. What do y'all really like? I think for me, it's got to be the political debates in my classroom. I love hearing what my teachers, what my students think. I'm the teacher. Sorry about that. I love hearing what my students think. I love hearing what my students have to say, hearing their political views. I just think it's very exciting. All right. Looks like we are unanimous, though, and y'all love the Supreme Court cases. And that's super good news for tonight because tonight is all about SCOTUS cases. In Unit 3, we have a ton of Supreme Court cases to go over. So Unit 3 is all about civil liberties and civil rights. And with civil liberties and civil rights, we've had a lot of Supreme Court cases that go with protecting those civil liberties and civil rights or establishing the civil liberties and civil rights. And it's the Supreme Court cases that made those changes. So we're going to talk about a lot of those. But just a heads up, this stream is being recorded. So it could appear on websites, YouTube, or other public channels. If you ask a question, your name could appear. So feel free to change your name if you don't want that to happen. All right. Also, we are on all the socials. Please, please, please look us up at Think Fiveable. We would love to connect with y'all and, see what y'all have to say, see what y'all think, all like that. We also have some trivia games coming up. These are super fun, and they are all about AP Gov content. So everything that we talk about today will be on the trivia game for April 1st. So make sure at 9:30 p.m. you log into that. You can click the link in the slideshow, and it will bring y'all to the actual AP Gov page, and you can access it through there. All right. So just another quick question while we're waiting for people to log on. Where are you from? I know we ask this every time, but it's like super interesting to me to figure out where people are from and what part of the country. And it could be all over the place, We have students all over the world that take this class, which I think is super cool. So I am in the South. I am a Southern girl, born and raised, born in Texas, but now live in Louisiana, and I've lived here most of my life. All right, Midwest, South. No one from the North? All right, very cool. Super excited. South wins. Not that we're playing teams, but yeah, that's awesome. Thank y'all all for tuning in tonight. So happy to have y'all here. All right, just a quick temperature check. How are you feeling about the AP test? Another question I like to ask every cram, just kind of seeing how y'all are feeling. So we're on the countdown, man, till the test. Things are coming in hot. I don't know which test uh, format or which test date you're taking. My students are taking it on paper at the very beginning. We're doing the first one. So very nervous about that, but very excited. All right, so let's see where y'all are at. So we got some okays, we got some not so goods, but no horribles, so that's good. But also no greats. But hopefully at the end of this cram, you'll be feeling a lot better, at least about Unit 3. And if you are feeling nervous about any of the other units, stick around, watch either replays, come around for the next couple crams, and then definitely make sure you chime in any questions that you have in the chat or in Discord. We have our fabulous TA, Amrita. She is with us tonight, and she will be answering any questions that you have. She is also super active in Discord. If you don't know what Discord is, say, hey, what's Discord? And we will help explain that to you. And we have a really good channel, and we are there to answer all of your questions as well. So if you don't feel comfortable asking them here, ask them in Discord. Okay, what else? Let's see, there we go, hide that. And last question before we get started. Did you attend the last cram session? Or any of the previous cram sessions? Since we're on our third one now. So it looks like we're kind of half and half. Whether you did or you didn't. If you didn't, that's okay. You can go back and watch the replay. That has everything there for you. And if you have questions on the replay, hit us up in Discord. We're happy to answer them. And don't forget, the Saturday before the first administration, we will be doing a 5-hour cram session. 5 hours. Oh my goodness. It is going to be intense, but it's going to be awesome. We are going to be doing all sorts of different activities and writing, things about writing, things about content, kind of the whole shebang in 5 hours. So I really hope that you will sign up for that. Or, well, if you're here, you've already signed up for it. You've already paid for it. It comes with your cram pass. But I hope that you will show up and do it with us, because it's going to be super intense, but super awesome. I have a fabulous AP Gov teacher that's going to be joining with me. His name is Robert, and he is from California. And I think y'all will love him. So we have already started planning that 5-hour. But if there's anything specifically you want to see in a cram or in the 5-hour cram, then let us know, because we're in the planning session and we love feedback and we love ideas. And we have Navia asking if there's a specific Discord for AP Gov, and the answer is yes. We have our own. So Fiveable has its own Discord, and then within Fiveable, there is a page just for AP Gov, where we are there to answer questions, give you feedback. You can, post whatever you want in there. Be like, hey, is this the right answer? I'm working on homework, I'm confused. Or what else? Say you have to write an FRQ for class and you're like, oh, I don't know how to start, or I'm confused about thesis statements. Whatever you have in there, like, throw out some questions and either Amrita will answer or I'll answer. But we are here to help. So use the resources. All right. All right. Oh, just heard from Amrita. She is having some technical difficulties, but if you have questions, feel free to put them in the chat and I will answer them after, or we'll answer them in Discord after. Feel free to post. So if it takes a minute for your chat to get answered, Amrita is working on it and she will get you an answer, but it might not be closer till the end of the cram. Natalia, are we going to be able to work on FRQs and MC questions for the 5-hour cram? Definitely. We want to teach as much content as possible while teaching FRQs and multiple choice questions is our goal. So we're working out what that's going to look like. But we are very excited about teaching exactly how to FRQ and how to answer multiple choice questions. And Robert, my co-teacher, is a specialist at multiple choice questions. So that is awesome. And FRQs, writing, is kind of my specialty. So with our powers combined, we should be able to offer you some really great tips. All right, where do you find our AP Gov Discord? Okay, so in Discord, this is a good question. A very good question. When you're in Discord, you want to get on the Fiveable page. And once you're on the Fiveable page, there is, let me see if I can pull it up and look at it so I can answer exactly. If I can't answer this question in like 10 seconds, Amrita will answer it for you when she logs on. Here we go. Sorry, drum roll. Okay, within Fiveable, when you get to Fiveable, you're going to go to the Getting Started, and then you will join the AP Gov page. If you have questions about that or how to do that, ask on the Fiveable website in the little chat box, and they will get you set up. And then when you scroll down under Subjects, Gov will show up. And I don't think I know how to share this. But if you ask the people of Fiveable, the tech department, they will get you an answer. And Amrita will be on soon and she'll help us too. I'm so sorry. I was trying to see if I could do it, but I can't. Okay. All right, let's get started. We have a lot to cover. So this is kind of what we're covering today. As you can see, a ton of SCOTUS cases. SCOTUS is going to be the priority of the night. So let's start with our introduction. So we have a very diverse America. You know, we talk about America being a melting pot. And people have used the institution of government to seek individual liberties and equality. So we want a country that has individual liberties, protects individual liberties, and has equality. So that's really what we're going to be fighting for throughout this entire unit. So first, we start with the Bill of Rights. And this Bill of Rights guarantees fundamental freedoms and prevents government from denying citizens free speech, free religion, privacy, a fair trial, and other essential liberties. The Supreme Court has ordered that states, too, must refrain from infringing on most of the same rights. So not only does the national government have to protect these rights, the state court has to protect these rights as well. So when we talk about civil rights and civil liberties, usually we immediately think about African Americans. So African Americans have overcome, you know, the notorious legacy of slavery, persevered through a century of discrimination before experiencing legal equality and fair representation. We have social organizations such as the National Association for the Advancement of Colored People, or the NAACP, and they have led the charge for racial equality. We'll talk about the NAACP through several court cases. You'll see them appear. And they have done a ton for lobbying for equal rights. So they have fought for racial equality, due process for Black defendants, school desegregation, and voting rights for more than 100 years. And by lobbying Congress, organizing public protests and voter registration drives, and pressing their case in courts, the NAACP and other civil rights groups has dismantled laws that denied equality to African Americans in the South. So we say specifically the South because the South is where we had the most issues, but really this is nationwide. And they're a group that is still fighting today to fight against any sort of equality issue. We're also going to talk about women, Asian Americans, Latinos, and the LGBTQ plus community. People with disabilities and other minorities have also taken a path towards equality via congressional laws, presidential directives, and court decisions. And this is something that we still see a lot today. It's still, a lot of progress has happened. We still have a lot of progress needs to be made. Still have a long way to go. So let's start with the Bill of Rights. So Americans have held liberty in such high regard in part due to the violation of several fundamental liberties by British authorities. So if we think back historically, we were under British rule and we wanted freedom, right? We wanted our liberty. So when we fought for that liberty in the American Revolution and we created our Constitution, we wanted fundamental protections, but we didn't put them in there right away. And so our original Constitution lacked the many fundamental protections, and the Anti-Federalists, or the people that were against the Constitution, Anti-Federalists, remember that keyword, they pushed for a Bill of Rights to protect civil liberties. And civil liberties are those personal freedoms protected from arbitrary governmental interference and deprivations by constitutional guarantee. So the Bill of Rights was designed specifically to guarantee liberties and rights. These civil liberties include protections of citizens through beliefs, opinions, and their right to express them. The Bill of Rights also protects property. The government can't take property away without just cause. The Bill of Rights guarantees a criminal defendant protection against government searches unless with probable cause, a right to cross-examine a witness, to refuse to testify, and to be judged by a jury of peers, and protection against cruel and unusual punishment. So I just thought this was cute. I found this online. The Atlantic put out this image, but here's a nice visual of our Bill of Rights. And so these are the first 10 amendments to the United States Constitution. So if you're like, oh no, what are the first 10 amendments? They are the same thing as the Bill of Rights. So when we talk about the First Amendment, we're talking about freedom of speech and religion, freedom of press, freedom of assembly, and freedom of petition. So you hear the First Amendment cited a lot, especially when we talk about key freedoms. The Second Amendment is all about the right to bear arms. Then the Third Amendment is quartering of soldiers. We don't have to house soldiers. We can't be forced to do that. The Fourth Amendment protects us against arrests and searches, or unlawful arrests and searches. Sorry, we can still be arrested, but just not unlawfully. The Fifth Amendment is all about the rights of persons accused of a crime. And so you'll hear things like, I plead the Fifth, meaning you don't have to incriminate yourself. Then we have the Sixth Amendment, the rights of persons on trial for crimes. So this is going to protect all of your rights that have to do with being in a trial. Then we have the Seventh Amendment, jury trials and civil cases. So it's going to do all the protections against that, and that's not one we talk about too much. So if you're trying to memorize the Bill of Rights, personally, I would skip the seventh and focus more on like the first, fifth, sixth. Then the Eighth Amendment, limitations on bail and punishments. So you can't have bail set crazy high or unfair punishments, things like that. Then the Ninth Amendment are the rights kept by the people. And the 10th Amendment are powers kept by the state or the people. So we're going to kind of talk about some of these more in depth, but if I were you, I would take a screenshot of this real fast just so you have it handy when you're trying to remember what the first 10 amendments are. Okay, then we have this handy dandy chart, which I found online. Thank you to studylib.net. And this is a quick rundown of all 27 amendments that we have. So the first ones in gray are the Bill of Rights, the first 10 amendments. Then there's a breakdown of all the other important amendments after that. So we're going to talk a lot about the 14th Amendment. You'll see that a lot in the SCOTUS cases, where the states cannot deprive someone of life, liberty, or property, or due process. And we're going to hear a lot about due process tonight. So you don't need to have all of these memorized, but you want to be familiar with this list. And if someone throws out something like the 14th Amendment, you want to know what that means. But if, you're not going to see like the 18th Amendment without it being cited, like making or selling of alcohol is illegal, like that, things like that, you can kind of skip over. So don't focus on memorizing all 27 of these and exactly what they say and exactly what they mean, but know the gist of all of them, and know key ones, like key amendments being like, we talk about like the 13th, 14th, and 15th, right after slavery was outlawed. These are the key kind of civil rights ones that we're going to talk about tonight. All right. So our first amendment, and this one is very important, and what falls under that is freedom of religion. So the beginning of the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So if you remember back in American history, a lot of people came to America searching for freedom of religion. So they wanted protection of religion, and so they made sure to protect that in the Bill of Rights. So that First Amendment is the First Amendment in the Bill of Rights. So as the nation became more diverse and secular over the years, the Supreme Court constructed what Thomas Jefferson has called a wall of separation between the church and the state. In this nation of varied religions and countless government institutions, however, church and state can sometimes encroach on each other. Like other interpretations of civil liberties, those addressing freedom of religion are intricate and sometimes confusing. Oh, yay! Amrita's here, our TA. She's fabulous. So now she will be much better at answering your questions, especially the tech ones, in the chat. So feel free to throw those up there and she'll be able to help you. All right. So back to freedom of religion. Members of the first Congress included the Establishment Clause in the First Amendment to prevent the federal government from establishing a national religion. So the Establishment Clause, just know in my crams, when you're watching my crams, if I've taken the time to bold and underline something, write it down. Make sure you know it. This is going to be a key idea from the unit that you need to know for the test. So the Establishment Clause, key idea, forbids the U.S. national government from creating a national religion and also prohibits government actions that favor one religion over another. So not only can we not have a national government, so we can't say like our national religion will be whatever. So we can't do that, but we also can't say we prefer X religion over Y religion. Then we have the Free Exercise Clause. And this is in the First Amendment, prevents governments from stopping religious practices. This clause is generally upheld unless a religious act is illegal or threatens the interest of the community. So the Free Exercise Clause protects the people's right to practice their religion as they see fit. And basically, a good way to think of this is as long as it's not hurting anyone, you're allowed to do it. But if anybody is ever in danger, then that is when that Free Exercise Clause is not going to hold up in court if someone's being hurt. All right, so this is always a hot topic, prayer in schools. So in the early development, public schools were largely Protestant institutions, and Protestant is a type of Christian religion. And so if they're a Protestant institution, that means they are Christian institutions, and that began their day with a prayer. So often schools started their day with prayer. But the court outlawed the practice in the early 1960s in the landmark case Engel versus Vitale. This was in 1962, and we're going to talk about that in just a second. But until then, it was very normal. The same way most schools stand up and say the Pledge of Allegiance, they would also pray. A year later, in School District of Abington Township, Pennsylvania versus Schenck, and this is not a key SCOTUS case that you need to know. This is just an interesting one. The court outlawed a daily Bible reading in the Abington schools in Pennsylvania and thus in all public schools. So 1962, we see the outlaw of prayer. And then in 1963, they outlawed reading the Bible like as a teaching in all schools in America. So in both cases, the school had projected or promoted religion, which constituted an establishment violating the Establishment Clause. So let's just take a quick question in the chat. So say I was going to, as your AP government teacher in a public school, or AP Gov doesn't really work. Let's say as your AP world history teacher in a public school, I want to learn about world religions, which is part of the course. And so we take a minute and we read key phrases from the Quran or key phrases from the Christian Bible. Is this allowed? Yes or no? So let's take a minute and answer that in the chat. Yes or no? Under the context of learning about world religions, can we read sections of the Bible or the Quran? All right, we've got one no, one yes, two yeses. All right, the answer is actually yes, we are allowed to do this. So you are allowed to read the Bible or read the Quran or whatever religious text you would like, as long as it's in the context of learning. If you are learning about a world religion in a historical context, then you can read parts of their scripture. Okay, say same classroom, I get up and say, as your teacher, I say, this is biblical truth. This is absolutely true and needs to be completely respected and worshiped. Can I say that as your teacher? And can we read it in that context? If I am teaching it as a religion, as your teacher, can you read parts of the Quran or the Christian Bible or whichever biblical text you would like? Good. No, we cannot. So do y'all understand the difference there? And when things can be introduced and when it can't? Let me know if you have any questions on that. And while y'all are getting questions ready, let's talk about our first required SCOTUS case of the night, Engel versus Vitale from 1962. And so the big constitutional question here is, does allowing a state-created non-denominational prayer voluntarily recited in public schools violate the First Amendment's Establishment Clause? And the answer was yes. So this is from 1959. Parents of 10 students organized and filed a suit against the local school board because this official prayer was contrary to the beliefs, religions, or religious practices of both themselves and their children. The lead plaintiff, Stephen Engel, and others argued that prayer created by a state actor and recited at a state-funded institution where attendance was required by state law violated the Establishment Clause. The respondent, William Vitale, was the chairman of the local Hyde Park, New York School Board. So, because it was a school-sponsored event, because they were not using it under a learning platform, because they had a person of power leading prayer and leading everybody in prayer and somewhere that everybody had to be, there was no choice of like leaving the room. It was deemed illegal. And so this is what they mean by taking prayer out of schools. Are you, as a student, allowed to pray in schools? Like if you went to your public school, are you allowed to pray? Let's see what y'all have to say. Yes or no? Can you pray in a public school as a student? Any answers? Yes, good job. Y'all correct. Yes, you are allowed to do that. As long as you are not disrupting the classroom and disrupting learning time, you are free to do that. But as a teacher of a public school, I cannot get up and say, we are now all going to pray together. Please join me for this prayer. So the reasoning of Engel versus Vitale is that the majority reasoned that since a public institution developed the prayer and since it was to be used in public school setting with mandatory attendance, the Regents Board had made religion its business, a violation of the Establishment Clause. Because the 14th Amendment and incorporation states, as well as the federal governments, are forbidden from officially backing any religious activity, it can't be done. We cannot have religion in schools. And so they also noted that including the word God was denominational because not every religious practice uses the word God, and not all religions believe in a God. Further, they explained that even though participation was voluntary, students would likely feel reluctant not to take part in teacher-led activity. And so I think this part is interesting. When we talk about positions of power and how positions of power are being used, teachers are in a position of power, and standing up and saying like, no, I will not pray with you, is not necessarily like an act of disobedience, but can feel like an act of disobedience for students. And so if we have to put you in a position where you have to feel like you're disobeying not to participate in something, like that's not okay. So the precedent that this set, and this is a big deal. So it set a precedent where the court has since ruled against student-led prayer at official public school events. The school has left open the possibility that an undefined occasional moment of silence might pass constitutional muster. So we might be able to have an occasional moment of silence. But outside of that and directed in any other way, it doesn't really fly. All right, our next goodest case is Wisconsin versus Yoder in 1972. So this big constitutional question is, does a state's compulsory school law for children aged 16 and younger violate the First Amendment free exercise clause for parents whose religious beliefs and customs dictate that they keep their children out of school after a certain age? And the decision was yes for Yoder. So the facts of the case is that a Wisconsin statute required parents of children aged 16 and under to send their children to a formal school. 3 parents in the New Glarus, Wisconsin school system, Jonas Yoder, Wallace Miller, and Aidan Yetzi, had teenagers which they did not send to school. Yoder and the others were charged, tried in a state criminal court, and found guilty and fined for not sending their children to school. These parents appealed the case. The state appealed the case in the state all the way up to the Supreme Court, arguing that their religion prevented them from sending their children to public school at their age. The school court agreed. The state court agreed, and state officials then appealed to the Supreme Court, hoping to preserve the law and its authority to regulate compulsory school attendance. The Supreme Court upheld the state court decision. Reasoning. So the court found that making Amish children attend schools would expose them to attitudes and values that ran counter to their beliefs. In fact, the court also said that forcing the Amish teens to attend would interfere with their religious development and integration into Amish society. Furthermore, the court realized that stopping schooling a couple of years early and continuing informal vocational education did not make members of this community burdens on the society. The court then declared in this case that the free exercise clause overrode the state's efforts to promote health and safety through ensuring full formal education. And Wisconsin versus Yoder is often cited for a lot of homeschool families. All right, so let's talk about freedom of religion. So contemporary First Amendment issues. So these are issues that we see often today. So these are real and perceived excessive entanglement between church and state continue to make the news today. So what do you think we mean by real and perceived? Real and perceived excessive entanglement. What is a perceived excessive entanglement versus a real one? While y'all are typing out those answers, let's ask, can government funding go to private schools or universities at all? Does a display of religious symbols on public ground constitute an establishment of religion? As with so many cases, it depends. So when it comes down, it really comes down to case-by-case basis, and that's what makes it difficult. So public funding of religious institutions and vouchers. I know the voucher system has been in the news a lot lately. And this voucher system, the supporters of private parochial schools, and that means usually religious schools, argue that the government should issue vouchers to ease their cost. Parents of parochial students pay the same tax dollars as public school parents, while their children don't receive the services of public schools. A Cleveland, Ohio program offered as much as $2,250 in tuition reimbursement for families sending their children to private schools. The court upheld this program largely because the money was going back to the parents, not the schools themselves. But we'll also often see these issues of whether or not public funding can go to religious institutions. And in this case, the money was going to the parents, not to the schools themselves. So it was seen as fine. It was not a violation of anything. The argument against using the voucher system is then if we gave parents a voucher and then they could use that as money to attend whatever school they wanted, it could take money away from public schools, and public schools are often very unfunded now, or underfunded. And so if we took more money away, we could have some serious problems. But then people argue for the voucher system, saying that their money, their tax dollars should go where their child is attending school. So pros and cons, you can argue both sides, as many people do. So then we also have religion in public schools. Since the Engel and Abington decisions, any formal prayer in public school and even a daily routine moment of silence are considered violations of the Establishment Clause. And so remember how we said we could have a random moment of silence? Depending on the situation, we can do that, yes. But interestingly enough, a routine moment of silence, where if every single morning we say everyone stand up, we're going to have a moment of silence, that is deemed illegal. So I think that's very interesting. But both of those things are considered violations of the Establishment Clause. The court has even ruled against student-led prayer at official public events, even though it's student-led, because it is being led in front of other people, and people are going to feel like they have to participate. It is illegal. However, popular opinion has never endorsed these stances. Popular opinion of the United States has always gone against this. In 2014, Gallup found that 61% of Americans supported allowing daily prayer. 61%. But students can still operate extracurricular activities of a religious nature, provided these take place outside the school day without tax dollars. The Free Exercise Clause guarantees students' rights to say private prayers, wear religious t-shirts, and discuss religion. Public teachers' actions are more restricted because they are employed by the state. So students are free to talk about their religion, practice their religion. That under freedom of religion, they are allowed to do all of those things. But teachers, as employees of the state and as people in power over students, are not allowed to teach religion in the respect that this is the one and only religion and this is true and everybody has to follow it. Teach about different religions, that's fine. Teaching one true religion, wrong. All right, freedom of speech. So freedom of speech is one of the cherished liberties. Quick question. So how does a moment of silence relate to religion? I think it's because historically, when we take a moment of silence, that is giving people an opportunity to pray. And so it's kind of ambiguous. But that's a good question. So an ambiguous hint towards religion, like we even want to stay away from that. Hope that answers your question. All right, back to freedom of speech. So freedom of speech issues extend much further than just words that come out of an individual's mouth. This right can inspire passionate arguments to protect and to limit speech depending on its content. The Supreme Court has ruled on this right many times. The court's interpretations relate to topics like offensive or obscene speech, protest speech, symbolic speech, and the right not to speak. The creators of the First Amendment meant it to prevent government censorship. So when we talk about freedom of speech and censorship, it's important to note that we talked about this a lot in my classroom. Just because you have something to say, does that mean anybody has to listen to you? Under freedom of speech, does anybody have to listen to what you say? Let's see what the answers are on this one. Just because you have freedom of speech, does anybody have to listen to what you have to say? Any opinions? Good. No. Yes. Very good. So round of applause for y'all. No. Nobody has to listen to what you have to say just because you have the freedom of speech. And so if you say something that someone doesn't want to listen to, the argument, freedom of speech, I can say whatever I want, doesn't hold true. Freedom of speech is freedom from government censorship, and that's what's really important. So symbolic speech also falls under free speech. So we're going to talk about a couple cases, especially Tinker versus Des Moines in 1969, where the symbolic speech of wearing black armbands was called into question. So even though they technically weren't saying anything, it's going to fall under freedom of speech. And so this is a very important case. What type of speech is restricted? So restricted speech is going to be, let's see, with freedom of speech, we're going to get like hate speech is restricted. There are several different types of speech that you can't like print in the newspaper lies about somebody that could ruin their life. Like that goes against freedom of speech. Like there are going to be like several things. Yes, encouraging violence, anything encouraging violence or encouraging hate is going to be outlawed. And then also when we talk about freedom of speech being restricted, often people want to talk about where their speech is happening. And if it's happening in a private institution or on a private institution's site, then you can't say whatever you want. So when we talk about things like writing things on Facebook, writing things on Twitter, writing things on Instagram, you agree to the site's terms and conditions. And so you can't just write whatever you want. If you are in a private institution, just any sort of like business or church or school or wherever you want, if you are on private property, you can't just say whatever you want. It has like, they have the right to refuse you of whatever service they are giving in that private building. So in Tinker versus Des Moines, the constitutional question is, does a public school ban on students wearing armbands in symbolic political protest violate a student's First Amendment freedom of speech? And the decision was yes. So in Des Moines, Iowa, there was a brother and a sister, Mary Beth and John F. Tinker, and their friend, Christopher Eckhart, and others developed a plan for an organized protest of the U.S. involvement in the conflict in Vietnam. So they wanted to wear black armbands for a period of time, as well as have 2 days of fasting. And the school administration, when they found out about their plan, they said, if you do this, we will suspend you. So the school banned the armbands, and when students refused to take them off, they were suspended until they were willing to come back without the armbands. The students decided that they were going to sue the school on the grounds of free speech and eventually appealed it all the way up to the Supreme Court. So, the reasoning behind this was noting that the record or facts showed no disruption took place. So, when we talk about freedom of speech, is it hurting anybody? That is the ultimate question that with any sort of freedom that you have, break it down to, is it hurting anybody, directly or indirectly? If it is hurting someone, it probably is not covered by a freedom. If it's not hurting anybody, you're probably allowed to do it. That is kind of my fail-safe method of figuring out what falls under a freedom under our Bill of Rights or not. So just break it down. Is it hurting somebody? Is it not hurting somebody? So wearing an armband to school, is it hurting anybody? No. So they said that because no disruption took place, no one was being hurt, the court ruled in the favor of the students who challenged the suspension, declaring that the students' right to political symbolic speech based on the First Amendment overrode the school's administration's concerns for potential disorder. So because no disorder took place, they couldn't make a decision based on potential disorder, that they were protected under the First Amendment. So under Schenck versus United States, this also has to do with First Amendment freedom of speech. This is in 1919. The question is, does the government's prosecution and punishment for expressing opposition to the military draft during wartime violate the First Amendment's free speech clause? And the decision was no for the United States. So the facts of the case. As the U.S. was entering World War I in 1917, sedition and espionage acts prevented publications that criticized the government, that advocated treason or insurrection, or that incited disloyal behavior in the military. As U.S. District Court tried and convicted Charles Schenck, the secretary of the Socialist Party, when he printed 15,000 anti-draft leaflets intended for Philadelphia area draftees. In an effort to dissuade people from complying with the draft, he argued in his pamphlet that a mandatory military draft or conscription amounted to involuntary servitude, which is denied by the 13th Amendment. So involuntary servitude, what is he meaning there? He's talking about slavery. So the government was very concerned at this time about the Socialist Party, German Americans, and those who questioned America's military draft and war effort. So Schenck appealed the guilty verdict from the district court. So the reasoning on this case is, on hearing the case, the Supreme Court drew a distinction between speech that communicated honest opinion and speech that incited unlawful action and thereby represented a clear and present danger. And this is so important, clear and present danger. You're going to see this a lot, hear it a lot, so make sure you remember it. If something represents a clear and present danger, then it's illegal. So in a unanimous opinion, the court upheld the government's right to convict citizens for certain speech. Schenck went to prison, as did defendants in 5 similar cases at the same time. The clear and present danger test became the balancing act between competing demands of free expression and government needing to protect a free society. So this is the rule of thumb that we use to protect our society. So when you say, well, I have freedom of speech, I can say whatever I want, the government's going to respond with, does it present a clear and present danger? Like, is there clear and present danger with what you have to say? And if the answer is yes, you can't say it. So same thing about clear and present danger, same thing like what I was saying earlier with, is it going to hurt somebody? And if the answer is yes, somebody is going to be hurt directly or indirectly, it can't be done. It's not protected by a freedom. All right, so let's break down the freedom of speech. So press and speech kind of go together. So we're going to see, like in Tinker versus Des Moines, they didn't actually say anything. It was just wearing the black armbands, but still protecting against free speech. Written in the press, protecting against free speech, and then actual verbal speech all falls under this First Amendment. And so the court has not made much distinction between speech and press, and ordinarily provides the same protective standards for both rights. Speech includes an array of expressions, actual words, the lack of words, pictures, and actions. So just as you have the right to speak, you also have the right not to speak. The First Amendment does not protect all speech or all press, especially if communication invites danger. So, Thomas Jefferson wrote, "Our liberty depends on the freedom of the press, and that cannot be limited without being lost." The absolute preservation of a free press, Jefferson's words signify, assures the transparent and honest government. So, what this means is that if we take away freedom of speech from our press and say that our press is not allowed to write whatever they want about the government, we're not going to have an honest government, right? Being able to report accurately on what's being done in the government means that there's transparency and we can decide whether or not to keep that person or that party in office. So we need freedom of speech to have a free government. So let's talk about libel. So libel refers to false statements in print about someone that defames or damages that person's reputation. But the American courts have typically allowed for a high standard of defamation before rewarding a suing party a win in court. So what we mean by a high standard means we allow a lot to happen before we decide, like, yes, we're going to say that there was defamation. The suing party must prove that they were damaged and that the offending party knowingly printed the falsehood and did so maliciously with the intent to defame or hurt. And this is very hard to prove. Public officials are less protected than regular people and cannot recover damages for defamatory falsehoods relating to their official conduct unless they can prove actual malice, that is, reckless disregard for the truth. And how hard is it to prove that someone was acting maliciously? Very hard. We aren't mind readers. We can't say exactly what they were thinking when they printed it. And because we don't have that ability, this is just very, very, very hard to prove. So the court later broadened the category of public figure to include celebrities such as movie stars, top athletes, and business leaders. Which brings us to the New York Times Company versus the US in 1971. And so the constitutional question here is, can the executive branch block the printing of reporter-obtained classified government information in an effort to protect national securities without violating the First Amendment's free press clause? And this decision was no for the New York Times. So in this case, Daniel Ellsberg, a high-level Pentagon analyst, became disillusioned with the war in Vietnam and in June of 1971 released a massive report known as the Pentagon Papers to the New York Times. This case also included the Washington Post because it too had been given the same documents. This 7,000-page top secret document told the backstory of America's entry into the Vietnam conflict and revealed government deception. These papers questioned the government's credibility, and President Nixon claimed hampered the president's ability to manage war. So Nixon's lawyers petitioned the U.S. District Court to order the Times to refrain from printing in the name of national security. The lower court obliged and issued an injunction, and that's like an order, and armed guards arrived at the newspaper's office to enforce the injunction. The Times appealed, and SCOTUS ruled in Times' favor. The ruling assured that the hasty cry of national security does not justify censorship in advance, and that government does not have the power of prior restraint of publications. But the court ruled on the newspaper's right to print these documents, not Ellsberg's right to leak them. In fact, Ellsberg was later indicted under the 1917 Espionage Act. So I think that's very interesting that it really comes down, when it comes down to SCOTUS cases, it comes down to constitutional truth. And that's what we talk about in my classroom all the time. What is constitutionally true? Not necessarily what you think is right or wrong. And what you think is right or wrong might not necessarily be constitutional truth. But in this class, we stick to the Constitution. So let's talk about prior restraint. And this is the right to stop spoken or printed expression in advance. And they deemed that the government does not have prior restraint. The government has no exclusive privilege of prior restraint, meaning the government can't stop something from being spoken or printed before it happens. Governments cannot suppress a thought from entering the marketplace of ideas just because most people see the idea as repugnant or offensive. A government that can squelch ideas is one that violates the very essence of free democracy. So, the whole idea of free democracy and our free government is that we can have freedom of ideas, freedom of speech, and be able to share all these ideas. So, if we shut down ideas, that is violation of freedom of speech. Does this mean, so we talked about earlier, that private companies, organizations, or people have to listen to you and have to listen to what you have to say? No, they are private and have their own rules, own regulations, and their own codes of conduct that can limit their ability or desire to listen to your thoughts and opinions. This is not censorship. So a lot of times when people love to throw the word censorship around and you're censoring me and you're violating my freedom of speech, that's not true, because if it is a private entity, it doesn't fall under this. So censorship specifically applies to government. And so censorship is when the government suppresses or prohibits any parts of books, films, news, etc., that are considered obscene, politically unacceptable, or a threat to security. So the right to bear arms. So this is something that is definitely in the news a lot right now. The right to bear arms and what all does that cover. So at the 1787 Philadelphia Convention or Constitutional Convention, when the Constitution was originally written, the debate about weapons was generally related to a standing army. In the light of the recent Shays Rebellion, which we talked about in Unit 1, several attendees were inclined to enable Congress to maintain a regular armed force, a paid, professionally trained military. And then I thought this was really interesting that Michael Waldman, in his book, The Second Amendment, writes, there is no evidence from James Madison's notes or those of any other participant that the delegates of the Constitutional Convention had the slightest inkling that private gun ownership was viewed at risk and required inclusion in a Bill of Rights. It simply didn't come up. So what we talk about as the right to bear arms is not what was actually historically written about with gun ownership. So gun regulations were common during the Founding Fathers' time, and regulations about gun ownership was super normal. Various states and localities maintained laws that, among other things, designated the official location for gun and powder storage, barred firing guns within city limits, and prevented people deemed dangerous from gun ownership. That was all very normal during the Founding Fathers' time. So much gun law came via common law court rulings. Gun ownership was common and protected. It was very normal for people to own guns. The legal argument for using a gun in self-defense was well established, but courts would eventually weigh the right to own a gun against the regulations meant to protect others. So when we talk about the Second Amendment versus gun policy, and how do these two things go together? So SCOTUS interpretations of the Second Amendment represent a commitment to individual liberties. So the Supreme Court is always going to err on the side of individual liberty. The amendment read, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The precise meaning of this amendment is hard to determine today, and that's why there's so much debate surrounding gun control. Today's gun control advocates might point out these state militias were well regulated and thus subject to state requirements such as training, occasional military exercises, and limitations on the type of gun possessed. So a lot of people would say that there was a lot of control over it and that there still should be. But then we have today's gun advocates, and they argue that the amendment guarantees the personal right to own and bear arms because each citizen's right to own a firearm guarantees the state's ability to have a militia. Similarly, gun right proponents argue that the rights of the people clause means the same as it does with other parts of the Bill of Rights. That is, that it supports people's rights and the people's rights to own guns. So basically the same verbiage in the same amendment, you can see the amendment's not very long at all, is used for both gun control and gun advocates. So while the First and Second Amendment focus on guaranteeing individual liberties in relation to speech, religion, assembly, and bearing arms, Other amendments in the Bill of Rights protect minorities and vulnerable populations through the Due Process Clause in the 5th and 14th Amendment. So minorities and vulnerable populations refer to those suspected or accused of crimes, the poor, and the indigent. Constitutional provisions also help guide conflicts between individual liberties and national security concerns. Government laws and policies balancing order and liberty are based on the U.S. Constitution and have been interpreted differently over time. Then we also have cruel and unusual punishment and excessive bail. And this is where the 8th Amendment prevents cruel and unusual punishment and excessive bail. Capital punishment or the death penalty has been in use for most of U.S. history, and it was allowed at the time of ratification of the Constitution and the Bill of Rights. So, but that has always kind of been in question about whether or not capital punishment is cruel and unusual punishment. The 5th Amendment also refers to individuals being deprived of life, and there is nevertheless debate about whether the death penalty fits the definition according to the framers as cruel or unusual. So that's kind of an interesting side note that people will use to argue that. All right, search and seizure. So among the grievances that pushed the colonies towards revolution was the British practice of search for smuggled goods. The British government issued writs of assistance, broad search warrants that enabled British soldiers to search any vessel, warehouse, home, or wagon. Conflict between their overly aggressive soldiers and the already freedom-deprived colonists propelled the revolution. When the revolutionaries worked to design the new government, they remembered this miserable chapters in relations between the colonies and Britain, and James Madison in the First Congress added the 4th Amendment to prevent a recurrence of such government overreach and violation of liberty, especially in the home. All right, so, and basically, with search and seizure, you have to have probable cause. And probable cause is a reasonable amount of suspicion that a crime has been committed. Sorry, I don't know if y'all can hear that. My dog's going wild. Buddy, chill out, dude. Sorry about that. All right, so let's talk about this one's a little confusing. Selective incorporation. This is the process of declaring only certain or selective provisions of the Bill of Rights applicable to the state rather than them all at once. And then we have due process, which is the concept of fundamental fairness that ensures legitimate government in a democracy. So with the 14th Amendment, the ratification of the 14th Amendment strengthened due process. Before and during the Civil War, Southern states placed many restrictions on basic liberties or lack thereof of American citizens. After the war, Union leaders questioned if Southern states would comply with new laws that protected due process, especially for former slaves. To ensure that slaves would follow these commonly accepted principles in the Federal Bill of Rights and in most state constitutions, Republicans in the House of Representatives drafted the most important and far-reaching of the Reconstruction Amendments is the 14th Amendment. And it's really important that we know the 14th Amendment because it is used in so many cases. And the 14th Amendment reads, all persons born or naturalized in the United States are citizens, and that no state can deprive any person of life, liberty, and property without the due process of law. So if I had to know one amendment, it might be the 14th because it comes up a lot. All right, well, we are out of time tonight, but feel free to jump on over to the Discord channel and we will keep talking and keep diving into this. So if you don't know how to do that, write in the chat real fast and we will help you out. Amrita has just put the Discord link in there. We would love to see y'all on Discord, love to talk to y'all more. There's like audio options, you can talk to us and we can answer any questions that you have. Also, I am going to, I'm going to post a link to the presentation from tonight in the chat. And so you can go over everything and then cover anything that you haven't, that we haven't finished yet. We've got a couple more SCOTUS cases that we didn't get to, but we will get to those in the 5-hour stream. So use this slideshow to go over it on your own, then come ask questions in Discord and I will answer them for you. and then we will talk about it again in the 5-hour. All right. Well, y'all are awesome. We will see y'all very soon. Let us know if you have any questions. Happy to answer them. All right. Y'all have a great night. Thanks, guys.